Hello, everybody. Welcome back again. This is Charles Rather, immigration attorney here in South Florida. What about appeals, right? Everybody watches, People's Court, and they watch all these court shows and dramas and series that talk about, if you lose, you go to court, appeal it, and you win. I have to tell you, in the immigration sector, that's not always the best strategy. There are cases, of course, where it makes sense to go to court and it makes sense to appeal a decision. But the reality is, first of all, in many cases, you're even prohibited or prevented from doing so. And even when you are able to do so, I'd have to say in the majority of cases, it's just not worth the client's time and money to do the appeal. And in worst case scenario, it's oftentimes just better to refile the petition, maybe make some changes, some tweaks, add some additional information and refile it. In many cases, that's probably the best option. But let's go through here a number of different scenarios that might be relevant to you, to your particular situation, so you can evaluate, is it really worth going to court or not? Or even just appealing it with the Immigration Service. You don't necessarily have to go to court to appeal something. Now, the first thing is you need to be clear about is if you get a denial at the embassy, forget it. Game over. The U.S. embassies and consulates are like separate governments that live by their own rules and their own regulations, and the procedures that apply to us mere mortals here in the U.S. of A. don't apply to the consulates. I think it's very unfortunate, and it maybe in some ways leads to arbitrary and unjustified decisions at the consulates, and they can basically do whatever they want. There's a rule that's called the non-reviewability of consular decisions, and it basically courts have kind of established over the years that, hey, we're giving the consulates carte blanche to make decisions about issuing visas or revoking them and stuff like that, and the courts aren't going to second guess these decisions being made by the consulates. And I think in general that's probably a good practice, but there are some really bad cases that sometimes occur, bad decisions, and there's just no recourse, and then there's no way to give feedback to the State Department that, hey, you guys, you need to correct this or maybe look into this so this doesn't happen again. There is what's called LegalNet. That's kind of the legal department of the State Department in Washington, D.C. So that's kind of an internal department you can appeal to with your attorney about the legalities, the propriety of certain consular decisions. And it can work, but it takes a long time. It probably takes 6 to 12 months to get a decision out of them. And so it's not the fastest process and not always very transparent either. So again, first point, if you've got a denial at the embassy for an immigrant visa, non-immigrant, tourist visa, stuff like that, I would just say cool your horses. You aren't going anywhere with any appeals. Even if you have all the money in the world, you want to go to court, it's not going to go anywhere, unfortunately. So that's in part why when we're deciding with clients whether to file for something in the U.S. or outside, we often make the decision, or the recommendation at least, to try to do it in the U.S. Because if you do get a denial in the U.S., there's a lot of reasons why it's a little bit easier to either fix it, amend it, or get it overturned. First of all, you have recourse to courts in the U.S. You also have recourse to the USCIS offices that review appeals as well. So instead of immediately going to federal court, in many cases it makes sense, and sometimes you're required to first go through the appeal process within USCIS. For example, they changed it recently with EB-5. Previously with the EB-5 law, if you got a denial, like say of your 526 of your conditional green card, you could immediately go to federal court. And that's what a lot of people did, and I think that was the best way to get a fair and objective hearing on the merits of the case. Now with the new law that was passed in 2022, you cannot go to federal court first before you exhaust all appeal procedures within USCIS. And unfortunately that slows things down significantly. Those appeal procedures can take certainly months and probably years in most cases. So unfortunately that's going to deny a lot of EB-5 investors the options of relatively fast review of any denials they might get. So again, summarizing, if you're here in the U.S., you certainly have recourse to all federal courts to review it. You have recourse to the appeal bodies, or departments, call it that, within USCIS if you get a denial. In addition, you can always just, as I mentioned before, always just refile. And I would say probably 80–90% of the time, that's probably our recommendation to our clients. Again, depends on their particular situation, and there could be cases where the only real option is appealing either through USCIS, through their appeal procedures, or going to court. What would be an example of that? For example, let's say your child was about to turn 21 when you filed for your immigrant visa. It doesn't matter, NIW, EB-5. And you filed in time just before the child became 21. So in the event of an approval, child would be okay, go along with you. But in the event of a denial, then your child, doesn't have that option to go together with you in the future. So in that case, let's say while you were waiting for an approval, your child turned 21, became an adult, at least for purposes of USCIS. And if you were to refile a new case after that, your child would not be able to go with you. So in cases like that, where children have aged out, as we call it, the appeal oftentimes is the only real option, because if you appeal it, then they're going to go back, they're going to date or backdate the whole process to when you originally filed your petition. So if you file an appeal, and it could be in federal court or it could be with the internal appeal procedures in USCIS, if you go that route then and you do win, well, then they're going to treat it as if your originally filed petition had been approved. You had originally filed it before your child turned 21. Therefore, your child is able to go with you further once you get the approval and receive the same benefits that you do. So again, the appeal process is fraught with a lot of complications. And recently we've had increasing problems at the consulate, and it becomes very frustrating because there's just so little that we can do at the consulate. Of course, you can try appealing to the consulate directly, and we've done that on occasion. That's usually not effective, because if these are the people that gave you the denial, it's very unlikely, even if you get through to a supervisor, that they're going to say, well, sorry, yeah, this was a big mistake on our part, sure, we'll give you an approval. I mean, chances are very slim. Then your only options really at that point are to go through LegalNet and some other options. It can be a very ornate or detailed process. Sometimes people even take lie detector exams, submit those results and stuff like that. Again, collecting all necessary data to show that the decision that was made at the consulate was incorrect. If you're trying to appeal a decision that was made here within the US by USCIS, process is a little bit different, more transparent, a little bit, I shouldn't say a little bit, quite faster as well. But then again, it could be an option of it's just like say, hey, let's just repair, improve, make some changes to the petition and file it from there. So hopefully this gave you a little bit of an idea what to do in the event if your initial plan A didn't go through, what's your plan B and plan C, and how can you maybe go forward with it. If you have any questions, feel free to ask them here in the commentary or give us a call to set up a consultation. Thank you.